A Supreme Court warning just put slow-walking gun permit offices on notice. And if your local agency is dragging its feet, this could be the beginning of a major legal shift for you. Quick question before we continue. Are you subscribed yet? Because the people who miss updates like this are usually the same people who learn the law after the damage is done. Hit that button now, because what I'm about to show you could save you months, maybe years, of waiting and a whole lot of legal trouble. Here's what just happened. A lot of people online are screaming that the Supreme Court already ended permit delays for good. That is not exactly true, and this is where you need to slow down and pay attention. The honest answer is more powerful than the clickbait. The Supreme Court has not issued one magic order that wipes out every gun permit rule in America overnight. But the court has done something that may matter just as much. It has made clear again and again that the Second Amendment is not some weak second-class right. Pause. And now, lower courts, state agencies, and even the Department of Justice are being forced to deal with that reality. First thing you need to know, the legal fight today is not just about whether a state can require a permit. Even Justice Gorsuch said states can require licenses before carrying in public. But he also said licensing systems can become so restrictive that they violate the Second Amendment. That is the key. Not every permit system is illegal, but a permit system that stalls, blocks, or buries you in delays may cross the line. Let me break that down in plain English. Most people think the fight is only about may issue versus shall issue. In other words, can the government deny you because it thinks you do not have a special reason? That was a huge issue in Bruin, but here's the part nobody talks about enough. A right can be denied without a direct no. Sometimes the government denies your right by making you wait so long that the right means nothing by the time you get it. Imagine you live in a high crime area. Imagine threats are real. Imagine you apply today, follow every rule, pay every fee, turn in every document, and then hear nothing for a year, or 2 years, or longer. At that point, what do you really have? A right? Or a waiting list? That question is now front and center. Now, this is where it gets interesting. In a case called Wilson versus Hawaii, the Supreme Court did not fully take the case, but Justices Thomas and Gorsuch sent a loud message anyway. They said states can have licensing systems, but those systems cannot be so restrictive that they break the Constitution. That matters because it tells every city, county, and state office in the country that delay is not some harmless paperwork issue. Delay can become a constitutional problem. Here's what most people get wrong. They think if the office eventually approves the permit, then no harm was done. Wrong. If the process is so slow that you cannot exercise your right when you need it, courts may start seeing that as part of the violation itself. And when I dug into this is the part that shocked me. The pressure is no longer coming only from private gun rights groups. It is also coming from the federal government. That changes the temperature fast. In March 2025, the Department of Justice announced a pattern or practice investigation into the Los Angeles County Sheriff's Department over concealed carry permit delays. The DOJ said it had reason to believe ordinary, law-abiding people were facing long delays that unduly burdened, or effectively denied, their Second Amendment rights. Read that again. Effectively denied. That is huge language. Then it got even bigger. In September 2025, the DOJ filed what it called its first affirmative lawsuit in support of gun owners. Not about criminal charges, not about a defense after the fact, a direct lawsuit. The claim was simple. Los Angeles County was allegedly slow-walking permit applications so badly that it was violating the Constitution. If you're finding this helpful, imagine what you'll learn in my next video about the exact words that can protect you when police start asking questions about your firearm. Subscribe so you don't miss it, because these legal details matter when real life gets messy. Now let's talk numbers, because this is where the story stops being theory and starts feeling very real. According to the DOJ complaint, between January 2024 and March 2025, Los Angeles County received 3,982 new concealed carry applications. Out of those, it approved exactly two. That is not 2%. That is 2 total approvals. The DOJ said that worked out to an approval rate of just 0.05%. But wait, there's something even more important. The complaint said applicants waited an average of 281 days just to begin processing. The median delay was 372 days. Some people allegedly waited as long as 1,030 days. That is nearly 3 years. And as of May 2025, the complaint said some interviews were scheduled as late as November 2026. Let that sink in. You apply for a constitutional right today, and the government tells you, maybe we'll talk in a year and a half. Pause. That is exactly why this fight matters. Here's a hypothetical example to explain this. Say you own a small business. You close late at night. You have had 2 recent break-ins in your area. You decide to apply for a carry permit because you want a legal way to protect yourself during those late night trips. You do everything right. You take the class, you file the paperwork, you pay the money. Then the office puts you in line so far out that your first meaningful step does not even happen for months, maybe over a year, maybe longer. That is not a small inconvenience. That is the whole right delayed. And there is an old truth in law that fits perfectly here. A right delayed can become a right denied. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. So what is the legal argument? It is not complicated. The argument is that the government cannot use endless delay as a backdoor ban. In other words, if the Constitution protects your right to bear arms, the state cannot pretend to honor that right while building a process so clogged, so slow, and so hostile that almost nobody can actually use it. And that argument is spreading. The DOJ's own investigation notice pointed to a federal court decision involving 2 private plaintiffs who challenged around 18-month delays in Los Angeles County. The government basically said, "We have seen enough. This may not be an isolated problem." That should get the attention of every permit office in America. Here's why this matters to you, even if you do not live in California. Bureaucracies copy each other. Bad systems spread, but court losses spread too. If one court says extreme delay violates the Second Amendment, lawyers in other states will quote that. If the DOJ wins or forces changes, other agencies may start moving faster just to avoid getting sued next. Second thing you need to know. This issue is not just a California issue. New York is dealing with similar complaints. A 2025 NY1 report described a federal lawsuit against the NYPD License Division over what the suit called excessive, unreasonable, and unjustifiable delays. One plaintiff reportedly waited about 17 months. The report said, New York state law requires licensing officials to act within 6 months or give a good reason for delay. Applicants said that rarely happened. And in one example, a man said when he finally picked up his permit, it had someone else's picture on it. Think about that. Not only delay, but basic administrative mistakes on top of delay. Hey, 73% of people watching videos like this are not subscribed. Don't be part of that group. Join the gun owners who stay ahead of legal changes instead of reacting after the fact. Click subscribe right now because this channel is built to keep you informed before a bad surprise hits your doorstep. Now, this is where a lot of viewers can make a serious mistake. They hear stories like this and jump to one of 2 bad conclusions. The first bad conclusion is, great, permits are dead. I can carry however I want now? No, do not do that. That can get you arrested fast. The current legal trend is about challenging unconstitutional delay and abuse in the system. It is not a nationwide green light to ignore your state's laws. The second bad conclusion is, well, if I'm stuck in a bad state, there's nothing I can do. That is also wrong. There may be a lot you can do, but you need to do it carefully. First, document everything. Keep copies of your application, save your payment records, save emails, save screenshots, write down the exact date you applied, write down every time you called. If your state has a deadline in the law, know that deadline. Second, make sure your application is complete. This sounds obvious, but here's what most people miss. A sloppy application gives the agency cover. If you forgot a document, they will say the delay is your fault. Do not hand them that excuse. Third, learn the trigger point in your state. Some states set timelines. Some allow extensions for good cause. Some do not. If your agency blows past the deadline, that may be the moment to talk to a qualified attorney. Fourth, do not confuse frustration with legal safety. I understand the feeling. You waited, you're angry, you feel disrespected, but carrying without the permit your state still requires can turn you from plaintiff to defendant in a heartbeat, and that is not where you want to be. Let me give you another real-world scenario. Imagine you get pulled over on the way home from the range. You have a firearm in the car. You think, my county took forever, but I applied, so I'm basically covered. Maybe not. If your state requires the permit in hand, I applied months ago, may not save you. That is why the delay issue is so dangerous. It creates a trap. People think the system is moving, but legally, they may still be exposed. Now, let's pull back and ask the bigger question. Could the Supreme Court eventually step in harder on permit delays? Yes, absolutely. Especially if lower courts split or if a pattern develops showing that states are technically allowing permits while functionally blocking them. That is the kind of issue that can climb fast. But here's the honest answer. We are not at the finish line yet. We are in the pressure building phase. The Supreme Court has laid down the principle. Justices have warned that licensing cannot become a constitutional choke point. Lawsuits are now attacking extreme delay directly. And the DOJ has shown a willingness to go after agencies it says are turning delay into denial. That combination is powerful. This is the part that shocked me most. For years, many gun owners thought the fight would always be about bans, magazine limits, or sensitive place rules. But now one of the biggest legal battlefields may be the permit office itself, not the statute on paper. The desk, the calendar, the backlog, the silent treatment. That is where rights can disappear without a dramatic headline. So what should you watch next? Watch for court orders forcing faster timelines. Watch for settlements that require agencies to clear backlogs. Watch for more lawsuits in major cities. And watch for a Supreme Court case that squarely asks this question: when does delay become denial? Because once that question gets a full answer, a lot of local systems may have to change very quickly. This information could change fast with the next wave of court rulings. Subscribe now, because the next video will break down exactly what you should do if your permit office blows past the legal deadline and leaves you stuck in limbo. Here's the bottom line. No, the Supreme Court has not issued one magical order ending every permit delay in America. But yes, the legal ground is moving fast. The court has signaled that licensing can exist, but not as a fake system that buries your rights under endless delay. And the DOJ's own lawsuit against Los Angeles shows that agencies may now face real consequences if they keep slow-walking law-abiding applicants. So do not make the mistake of sleeping on this story. Your rights are not just threatened by bad laws, they can also be threatened by bad process. If this helped you understand what is really happening, subscribe, share this with one gun owner who needs it, and stay alert. Because the people who stay free are usually the people who stay informed. And one final simple disclaimer. Laws vary by state, and this video is for education only. It is not legal advice for your personal case. If you are dealing with a delay, denial, or criminal risk, talk to a licensed attorney in your state as soon as possible.